I'm attorney Allison Harrison of ALH Law Group. I am joined by our probate and estate planning attorney, Alex Dixon, and we're going to have a conversation about what probate is and hopefully provide some clarity to folks having to go through the process. So tune in. So we're going to have a conversation about probate. So in Ohio, when do you go to probate?
When somebody dies?
Yes, when someone dies. But is there a threshold of like you have to open a probate? Are there assets that don't go through probate?
Yeah. So in Ohio, there's certain thresholds. So you can either go the small estate route or the full administration route. For a small estate in Ohio, if you are a surviving spouse and the assets total under $100,000, you can go small estate route. If there's not a surviving spouse, so anybody else that's trying to open this estate, if it's under $35,000 of total assets, then you can do small estate route.
Okay. And when you say small estate, what does that mean?
Yeah, so it's just a less of a process. A small estate takes less time, it's less expensive in attorney's fees, and there's a lot less forms and processes through the probate court. So if you have the option to go small estate route, that's really the more time efficient way to do things, the less expensive way to do things, but there's just certain requirements you have to meet before you can go that route.
When you say it's quicker, what's the timeline if you meet those under 100,000 or under 35?
Yeah, so we typically tell people about 2 to 3 months to really get everything. By the time we find all the assets, get everything filed with the probate court, get a hearing date set, ends up being 2 to 3 months.
Okay. And can someone do this by themselves? Do they have to hire an attorney?
Yeah, they could definitely do this by themselves. A lot of people choose not to because they're not used to the probate court processes and they just want an attorney to handle it instead of having to deal with it. But since it's a smaller process, they can actually go to the probate court and there's somebody that can help them. I think it's like 1 day a month. There's an attorney.
That's specific to Franklin County, right?
Yeah, specific to Franklin County. I don't know about the other counties. They might have that option too. But
Okay. And when we talk about if you exceed that, so if you have over 100,000 and you have a surviving spouse over 35, what does the probate process look like? Very high level.
yeah, so we would go full administration route. It's a much longer process. I would say most estates we handle are full administrations, but I like to think of it in 3 phases. So first phase is the asset gathering and opening the estate. So this is where we tell the probate court what's going on, who the people are, what the assets are that we know of. Second phase is the inventory. So this is where we really figure out the exact values of all of the different assets, tell the probate court about them, get their approval. And then the third phase is called the accounting. Accounting is where we have the option to sell off different assets, get the proceeds, put everything into one estate bank account. And then once we have court approval, that's when we can go ahead and distribute those assets to the people that get them.
Okay. How long does it take?
A normal full administration with no hiccups is about 6 to 9 months. Anything that comes up, like if there's obstacles, if there's some trouble getting things, it can take a lot longer than that.
And what are some obstacles that you run into? Is it like sending notice to folks or not being able to find assets or creditors? Kind of what are those hiccups?
Yeah, those are some of the hiccups. A lot of the things we run into, a lot of the obstacles we run into are just not being able to contact people. So we have to contact a lot of certain people. If they're heirs, we can't get a hold of them. The family member that we're in contact with, they don't have the address, things like that. And then there's a lot of delays in trying to figure out where the assets are. So if we need to contact the bank, if we need to figure out where a title is for a car or a boat, things like that, there's a lot of processes that we have to go through to get those documents, and that often can leave us waiting. The court can also take a while. So if we file the necessary documents and the court's backed up, we can't rush the court. We're at their mercy. So if they take a while, then we take a while, and there's nothing we can do about that.
Okay. So when we do this information gathering, when someone passed away and they have to go through probate, it's really important then for them to do their due diligence to figure this all out. It allows the rest of the process to go faster.
Yes. Yeah, I think that's one of the most important pieces of this. A lot of times we see surviving spouses are able to find those items a lot quicker in the same household. If there's not a surviving spouse, then it's up to the family members, the fiduciary, to go over to the house, try to go through all these documents, find bank statements, find tax returns, any documents you can find in their mail or in their records, and gather those and give them to us. That really cuts down on the time we have to wait.
And I think one question that we see a lot is like, do you have a magical wand you can wave to find the assets?
I wish.
Don't we all?
If I was given a magical wand, my life would be so much easier. No, I wish we did, but there's not a system that attorneys have or some kind of platform where we can access it, put in a social security number, and then all of their assets pop up. A lot of people that seems to be like a misconception, that we have that access, but we don't. We have to go and dig and figure out where these assets are, and really family members, loved ones are the best equipped to try to find those assets because they know their people. Unfortunately, we didn't know those people while they were alive, so it's a lot harder for us to guess where their bank account was, where their all their retirement funds are. So I wish we had that one.
Sure. And we hear a lot from the media or kind of clients coming in on the planning side that they have to name an executor. What is an executor? What does that mean?
An executor is somebody who is the fiduciary that's named in a will. The executor is the person who is later appointed to be in charge of the estate. They are tasked with reaching out to an attorney, responsible for gathering all the documents, making sure that everything is good to go and they're getting all the assets transferred to the probate court. We're certainly here to help them, but really they do have the responsibility to act for the estate.
Okay, and so the executor is the one that like goes to the bank and gets the closure check and empties out the safe deposit box if they have the right authority.
Correct.
Signs to sell the house if they're selling it. Okay.
They really are the person who can step into the deceased person's role and they can act as that person could have. A lot of times there's also a misconception that as the attorney, we can do that. I'll tell you that the banks and everyone else, they won't talk to us. So unless you're the executor or the appointed fiduciary, you can't do that.
And let's talk about the appointed fiduciary. So an executor comes if there's a will and someone's named, but what happens when either everyone in the will is unavailable or predeceases the decedent, or there is no will? Who steps into those shoes?
Yes. So as you're kind of alluding to, the term for that is fiduciary. So a fiduciary can either be an executor or an administrator. The executor is a person that's named in the will who is able and willing to serve as fiduciary and they're appointed. If you're not named in a will, then you are considered an administrator. Very similar roles. You're still in charge of the estate. You're doing all those tasks that the executor could do, but you're just not named in the will. So you would have to go through a little bit more of an obstacle to be appointed as the administrator. You typically have to post a bond in Ohio to say that you're responsible for the estate. And if you mess up, then you have some financial backing that would take care of that. But really, you still have the same responsibilities as an executor. You're just not named in a will.
And I think one of the things that we run into in the legal system is so much mail. Can we talk about the notices that have to go out and the ability to waive some of those formal notices? Because I think that's a misnomer of like in 2025, 2026, no one gets mail, but the court still loves to send stuff through the postal service.
Yeah, the court loves the pony mail. So all along the process of probate, like there's the 3 phases that we talked about. There's typically notice requirements at each phase of probate. And we're required to send these notices to specified people. At the beginning, we are typically sending notices to all the heirs that would be entitled to these things. If there's not a will, or if there is a will, we still have to send it out to everybody who would be entitled to it. But as we go along the way, we have to send these certified mail notices and either satisfy service by the mail being delivered, or we have to get it waived by the person. And they just basically say, I don't need the notice. You're telling me about it. That's good enough.
Okay. And when do people get paid? Like, this is like, everyone's like, I have an inheritance. I want it. I have plans for it. When in the process do those distributions go out?
Yeah. So typically we wait until the very end of probate for everybody to get paid out. There's instances where the fiduciary could be paid, like reimbursed for things before the final accounting is approved. But typically, for all beneficiaries and the fiduciary, we wait until the very end for the court approval.
And do you set up a separate bank account so that it's like all clear? Does it run through an attorney trust? Like, how are funds moved? So the decedent has money at a bank, but they can't stay there forever. Kind of walk me through that process.
Yeah. So, since an estate is considered separate from the deceased individual, we do have to set up an estate bank account. And we do so by establishing a separate employee identification number through the IRS. So they are considered separate. But once we have that set up, we're able to take those personal funds from the deceased and we go ahead and put it into the estate account so that the estate can manage it and the fiduciary can access it.
And can the fiduciary use those funds for whatever, or are there limitations on once it's moved in that estate account, how you can use the funds?
The fiduciary has a very specified purpose for what they can use those funds for. And typically, they have to have court approval to use those funds for anything. If they're reimbursing themselves, they can get approval from us or their own duties to do so, but we just have to keep a very specific accounting of what they're doing and using that money for. But they cannot use it for personal use. Even if they're entitled to it after the end of things, they are not permitted to take that money out and use it until the court tells them they can.
Thank you. It's very clear. I love it.
Very clear.
I love clarity. What are some of the things that would allow a probate to move quicker? You said it's a range of, 6 to 12 months. How do you get through quickly in 6 months, and what takes 12 to 18 months?
Yeah, so I love, love, love when clients come in and they know exactly where the assets are. They know the account numbers. There's no question about things. And they also are ready to provide contact information for everybody involved. So if I have an email address for everybody and I can get things signed by e-signature, that is ideal. So we don't have to send a lot of mail. Other things, just response time. If clients are willing to, get in this probate estate with me and they're willing to respond and get things done in a timely manner, that makes my job easier and it makes the estate go quicker. So we can get things done.
That's fair. I know sometimes I'll jump in here that we've had it where there are like 42 heirs because they're like second cousins or cousins, and that can create a very lengthy time because trying to get 42 people to sign anything just takes time, and getting the notices out there. And especially if they're older, we've had folks that have passed away while we're trying to probate one person's estate. The second, someone who is entitled to a distribution passes away. And so those types of things can slow down a probate process. The other types of things that might slow it down are debts, right? Let's talk about Medicaid, because that's a debt with elderly folks that pops up quite frequently. Where do you see Medicaid debts popping up? Is it on liens? Is it on claims being submitted? And how do those get paid out?
Yeah, so I've seen them as liens before. So the lien would attach to a house, and then before we're able to sell the house through probate, the Medicaid lien would have to be released. So we can negotiate with Medicaid in that situation, have the lien released, sell the house. The other way we see them,
and then they're paid off, right?
Yes. Yeah. We always have to pay off Medicaid. Medicaid debts do not go away. They will follow the estate until it's complete and the debt's paid off. But the other way we see them, they don't have to file a claim. So we have to reach out to Medicaid and ask if there is a claim on the estate. And the Attorney General.
Yeah, the Medicaid recovery department is basically the collection arm of Medicaid. It runs, the Attorney General is the attorney for any state agency in Ohio, and Medicaid is a state agency. It's a federal program, but it has a state component. And so the AG does the recovery. And so we work with the AG's office on getting those debts paid or negotiating them down if that's at all possible, because those do have to get paid out of the estate before we can finish distributions. What about taxes? So the person presumably died on some date other than December 31st, right? That's when our tax year ends. And so we have taxes that have to be filed. So we have taxes that are due. So you have the taxes for the year the person passed away. Just like you file your taxes every year, you have the taxes that are due April 15th of the following year after the person passes away. And then on any of the assets that are there, if they appreciate more than $600, there may be another estate tax return that's due. We work with accountants to try and get this done for our clients, but family is certainly willing to do it themselves. Not everything requires an accountant. We just connect with them so that you don't have to, like, families don't have to go searching for them. Motor vehicles. These are always fun because most people own at least one car. Is there an option to pass outside of probate, especially surviving spouses?
Yes. So with motor vehicles, if there's a surviving spouse, things are a little bit easier. Any motor vehicles up to $65,000 of value, so that can be as many vehicles as you have up to that amount, they can pass outside of probate to a surviving spouse. If there's no surviving spouse and there's not a transfer on death designation already listed on the title, then those motor vehicles have to go through the probate court. So they would transfer like everything else. They would either go through the will or they go by intestate succession through the probate court.
All right. Now let's talk about something because you said transfer and death.
Mhm.
Beneficiary. Are there ways that things don't go through probate but still get distributed to beneficiaries?
Yes. So when we're considering assets to go through probate, we consider probate assets or non-probate assets. To be a non-probate asset, it has to be transferred upon the person's death. So they could do planning before they die to set up transfer on death designations for their house, their vehicles, their bank accounts, retirement, basically everything you have. And we see this, bank accounts are normally called payable on death. So that would not have to go through the probate court. They would submit some documentation, have it transferred outside of the probate court. Anything that does not have a designation to transfer upon that person's death would then have to go through probate and would be considered a probate asset.
Great. And we're talking about beneficiaries. So life insurance policies, you often name who the payee is when you die. Car titles, you can put a transfer on death beneficiary. Bank accounts, you can put a transfer on death beneficiary. On your 401ks and investment, those allow beneficiary designations similar to life insurance, and those can pay out outside of probate. On the planning side, you have to take steps before you pass away for those things to pass outside of probate. Okay. Well, this was a lovely conversation, Alex. Thank you.